Do you want to do litigation, arbitration, mediation, or a combination of them? For those of you out there who may have contracts in front of you already, I'm going to quickly go through some of the differences with them. So with litigation is what we traditionally see as like going to court. I'll have my day in court, I'll see you in court. You file with the state, you go through different pleadings and motions. That's what we traditionally know as litigation. Now, as you also know as a business owner, it can be expensive. It's a lot of paperwork. It's a lot of legal language. And it's what we traditionally know as a way to resolve disputes. Just so that you guys know out there too, that it was recently changed where small claims court is now everything up to $8,000. That's 8. It used to be 5 and it changed. I believe it was the beginning of this year or last year. I'm not sure, but it changed where it's now $8,000. So you can take something to small claims court that's under $8,000. Also very important to know in litigation is that if you are a corporate defendant, meaning your company gets sued for something, you must be represented by an attorney. You must. Mediation is a process where you will choose a neutral third party to be able to listen to your dispute. With mediations, it's more private because now you're not in a public record system the way that you are with litigation. Mediation sometimes can be less expensive because you're not doing the filing of the pleadings and going back and forth and having legal representation that way. And with mediation, for you to be able to get to a settlement agreement, both parties have to agree. So it's basically someone that you pay to listen to both sides and help you get to a settlement.
Okay.
Arbitration, and you see this a lot in contracts as well. Arbitration is where you would choose neutral third parties, third persons, sometimes 1, sometimes 3, sometimes 5, it just depends. And that person will listen to your dispute, and that person acts like the judge, and they will determine who wins the dispute. Now with arbitration, you definitely have more privacy than you have within the regular court system because the documents are not necessarily public record the way that they are with the regular court system. You use less formalities than you would within a regular court system. And sometimes it may be less expensive. It just really depends on, I guess, the nature of the dispute. With arbitration, the parties do not have to agree the way that they are with getting a settlement in mediation. The arbitrator will make a decision for you. Just be aware of what's there as your dispute resolution, because if you have an arbitration clause within your contract, that is the way that you're supposed to deal with disputes, and you file a case within the court and you serve the person and you bring them to court, all that person has to show is that this is not the right forum for the dispute and that your contract specifically says arbitration, and then your case is going to be sent to arbitration, or you're going to get dismissed, basically. So it's very important to look at what your dispute resolution is and think about it. Do I want the privacy? Do I want it less expensive? Do I want to just have my day in court and go to small claims and do everything myself? What is it that you want as a way to handle a dispute?
The content on Minding Your Business is for informational and educational purposes only and should not be construed as specific legal advice. This show discusses general legal issues affecting business owners. Opinions of the guests are not necessarily that of the show. If you need assistance with your specific legal issue, please consult with a licensed attorney.